violent crimes. The 2020 graduating class selected her as the law school's Professor of the Year. Our next guest is Professor Mark Osler. Dr. Osler is the Robert and Marion Short Professor of Law at the University of St. Thomas Law School. He holds the Ruthie Maddox Preaching Chair at First Covenant Church in Minneapolis. His writings on clemency, sentencing, and narcotics policy have appeared in the New York Times, the Washington Post, and the Atlantic, and in law journals at Harvard, Stanford, the University of Chicago, Northwestern, Georgetown, Ohio State, UNC, William & Mary, and Rutgers. A former federal prosecutor, he later won the case of Spears versus United States in the US Supreme Court, with the court ruling that judges could categorically reject the mandatory 100-to-1 ratio between crack and powder cocaine in federal sentencing guidelines. Osler's 2009 book, Jesus on Death Row, critiqued the American death penalty through the lens of Jesus's trial. His second book, Prosecuting Jesus, is a memoir of performing the trial of Jesus in 11 states. In 2020, Osler served as chair of the independent panel which reviewed the case of Myron Burrell, and recommended that Burrell receive a commutation of sentence. Osler is a graduate of the College of William and Mary and Yale Law School. Last but certainly not least, this afternoon, we're pleased to welcome Dr. Rachel Paulus. When she was unanimously confirmed by the United States Senate to serve as U.S. Attorney for the District of Minnesota in 2006, Rachel Paulus became the first Indian American in American history to be nominated by the President and confirmed by the Senate for any federal appointment. She is, in addition to being a distinguished scholar, a frequently sought after commentator. She's provided legal analysis for the Washington Post, USA Today, Fox, Minnesota, ABC, CBS, NBC, NPR, and the St. Paul Pioneer Press, among many other media representatives. She has given keynote addresses at the North American South Asian Bar Association Annual Convention, the North American South Asian Law Students Association Annual Convention, and the National Asian Pacific American Bar Association meeting. She also presented at the Nobel Peace Prize Forum, the American Bar Association Annual Convention, International Business Law Institute, and Jewish Community Relations Council, Yale Law School, and the Harvard Law School, among other institutions. Dr. Paulus received her JD from Yale Law School, where she was a Coker Fellow, editor of the Yale Journal of Law and Feminism, and commencement standard bearer. She graduated summa cum laude with the BA from the University of Minnesota, which she attended on full merit scholarships, where she was the commencement speaker, chair of the student representatives to the Board of Regents, and Phi Beta Kappa. Thank you all for joining us this afternoon. We, of course, are here to talk about the upcoming trial of Officer Chauvin. And I want to begin with you, Mark, Dr. Osler, in particular, because I'm hoping that you'll be able to set the context for us and provide an introduction to this trial. What should people be expecting in terms of what we expect to see in the next few weeks?
Yeah, it's going to be fascinating. When we talk about the trial, we're really talking about two trials because there's 4 officers who have been charged. And what's going to start next week is the trial of Officer Derek Chauvin. The other 3 officers, their trial has been put off until late summer. So right now we're just looking at the one officer, and that'll be significant. I think some of the other experts will have something to say about that. What we're going to see is something pretty unique, and COVID influences the way this is going to play out. The courtroom itself is going to be different. There's going to be a limitation on the number of lawyers. There's only going to be a few media representatives that are allowed in the courtroom. That does change things. I mean, for example, even the fact that while they're being questioned, potential jurors may be wearing a mask. And that, of course, hides clues that we're usually going to be looking for. You know, how does someone look when the defendant walks into the room? When we pick juries, that's something we do. And when people are masked, that's going to be a new challenge. Now, people will be able to watch the hearing or the trial because it's going to be televised. And you can see that the Star Tribune is going to live stream it. In addition, Court TV, which is resuscitated, it was dead for a while, is going to be carrying it as well. And this is kind of interesting. I didn't know this. Court TV actually is over the air in Minneapolis. So if all you've got is a TV and an antenna, you can still watch the trial. Now, one thing I want to mention before I turn it over to the others is that what happened last summer was a profound incident and discussion involving race. And something that's going to be jarring to some is that this trial is not going to be about race. That in criminal law, what the government has to prove is the elements of the crime. The defense is trying to show doubt as to one of those elements. And none of those elements have to do with race. And that means that there's going to be a real disconnect between what goes on inside the fencing around the courthouse, where people will be talking about race, and what goes on inside that perimeter. I wrote about this for CNN, and that'll be coming up later today or tomorrow, probably.
Thank you. Appreciate that. Professor Moran, there's been a lot of conversation about the charges that we can expect in this case, legal wrangling over third-degree murder. Can you break down for us what we can expect with regard to charges, not only with regard to Chauvin, but the other officers who are charged in this case?
I definitely can, and I'll try to make this simple. So Derek Chauvin's trial is scheduled to start on Monday with jury selection, and remarkably, we still are not completely sure what charges he will be facing. There are 2 charges that are definite, and I'll explain those. The third charge, as Dr. Williams mentioned, has been very much up in the air, and I'll try to break down how that has happened. But the 2 charges we know for sure. The most serious charge is second-degree murder. A second-degree murder charge involves a maximum sentence of 40 years in prison. So it's a very serious charge. And there are a couple different ways the state can prove second-degree murder. But in this case, against Derek Chauvin, what the state would have to prove is that he unintentionally killed George Floyd, but he did so while committing a separate felony, which is the felony of assault causing serious bodily harm. So none of the charges require the state to prove that Derek Chauvin meant to kill George Floyd, but this most serious charge does require the state to prove that he knew he was committing an assault causing serious bodily harm, and that death unintentionally happened as a result of that assault. The least serious charge, which is still very significant, is second-degree manslaughter. That charge carries a maximum sentence of 10 years in prison. And the difference in the second-degree manslaughter is really about Derek Chauvin's state of mind. So if the state were, in order to find him guilty or to prove him guilty of second-degree manslaughter, the state has to show that he acted negligently, that he knew that there was a risk of death or serious bodily harm, and he negligently created that unreasonable level of risk. So that's kind of, it sounds like legal jargon because it is, but that's what the state has to prove, is that he was acting negligently. Again, not that he intended to kill, but that he created a risk, basically that he shouldn't have created, of death or serious bodily harm by his actions in kneeling on Mr. Floyd. The third possible charge is where things get really complicated. So back in the very first charge filed against Derek Chauvin, actually, and I can't remember if it was the very end of May or the beginning of June, but when Hennepin County was prosecuting this case alone, they filed a third-degree murder charge. After the Attorney General took over the case, they upped the charge to second-degree murder, but tried to also stick with third-degree murder as an alternative charge. And last fall, the parties had a hearing about these charges. The judge allowed the state to move forward on all but the third-degree murder. And at the time, the trial judge's reasoning was that because of the language of the Minnesota statute, he thought that third-degree murder only applies if you behave recklessly, but you create a risk not just to the person who dies, but to others as well. So third-degree, what we know third-degree murder requires is creating that your behavior is so, the language is eminently dangerous to others, that you exhibited a lack of regard for human life. But that language to others is where things get really confusing. The judge thought that meant that you have to create a risk of harm to multiple people. And in this case, only George Floyd was at risk of harm. So the judge dismissed the third-degree murder charge. And everybody moved forward thinking that that charge wasn't going to be part of the case. But about a month ago, in a different case, also involving a police officer whose name was Muhammad Noor, who was convicted of third-degree murder, the appellate court said the opposite of what the trial judge in Chauvin's case had said. They read that same statute and they said, your behavior only has to be risky as to one person, the person who dies. That's enough for third-degree murder. So once that decision came down, the state suddenly asked to reinstate the third-degree murder charge against Derek Chauvin. There's been a lot of legal wrangling about that. I actually checked about 15 minutes before this session was supposed to start because we are waiting to hear from the appellate court, which is the court that has authority to tell Judge Cahill in the Chauvin case what to do. We're waiting to hear if the appellate court is going to order Judge Cahill to reinstate the third-degree murder charge. We're also waiting for the Minnesota Supreme Court, the highest court in the state, to interpret more clearly what does this third-degree murder statute mean. But they've said they're not going to do that until this summer. So they have declined to shed light on the issue for the Chauvin case, at least at this point. So here we are just a few days before trial, and we don't know with any certainty whether the state will be moving forward with the third-degree murder charge. What we do know is second-degree manslaughter and second-degree murder are both the charges they are for sure pursuing. As to the other officers, I'll just speak to them really briefly. They are also charged with second-degree murder and second-degree manslaughter, but under a theory of accomplice liability, meaning that they helped Chauvin, that they did not personally murder Mr. Floyd, but that they assisted in the murder. The state is trying to also file third-degree murder charges against them, but none of that's going to be decided, and their trials aren't starting until August, so not as much of a concern yet as to how that will play out in those cases.
Thank you, Professor Moran, for that very clear explanation. I don't think I've seen it any place so clearly explained, so thank you. Professor Paulus, you bring a wealth of experience like everyone else to this panel, but I want to ask you to perhaps break down and do some trial foreshadowing for us. What will be the government's theory of this case, and what will be the defense's theory of the case as we watch this unfold in the next couple of weeks? Oh, you're muted, Professor.
Thank you. Thank you, Dr. Williams. I want to start by just saying this is an emotionally unsettling case for me personally. I cannot imagine what the Floyd family is going through right now, and I wish to express my deepest sympathy for their loss. I do think it is important for lawyers to speak clearly because we work in a profession where words matter. And so I am going to be speaking very clearly about what both the government and the defense have signaled about their theories of the case in response to your question, Dr. Williams. And at times where I think it's appropriate, I will quote from documents that some people might react to, but these descriptions are very explicit and they're very straightforward about the various theories that are being proposed. Really, this case comes down to cause of death. And no one disputes that Mr. Floyd was killed while in police custody. The question is, how was he killed? The government's theory of the case, in a phrase, is excessive force. So the government is going to argue that Derek Chauvin and his former colleagues, all fired from the Minneapolis Police Department, used inappropriate levels of force. By contrast, the defense is claiming that all the police, particularly Derek Chauvin, used reasonable force, and they are also going to claim that Mr. Floyd is to blame for his own death. So let me just walk through what the pretrial filings and public statements of both sides have already indicated. So first of all, the government has alleged that Derek Chauvin in particular had a modus operandi, meaning a practice of using holds on suspects and using excessive force. And they point out that he's essentially a bad apple who's faced 17 complaints over the years, including 3 shootings and 1 fatal shooting. The government also, I think, will walk very slowly and methodically through the timeline of what happened here. For anyone who's watched the painful video of what happened to Mr. Floyd, what was done to him, the government will walk through that minute by minute, second by second. They will point out that Mr. Floyd was handcuffed. He carried no weapons. He was speaking politely to the officers. He never at any point raised his voice, used profanity, or made any threats. By contrast, the police raised their voice, threatened weapons, used profanity. and threatened onlookers. The government will also point out that Mr. Floyd was initially very calm, while the police were, in their view, out of control from the outset. And they themselves initially described the scene as being under control. The government's theory of the case is also that Mr. Floyd became upset because he had just lost his mother. He had been shot by the police in the past. He had some claustrophobia, and he became very anxious as the police escalated their behavior. The government will claim that Chauvin in particular knew that Mr. Floyd was having trouble breathing, that he told officers he just had COVID, and that he said he could not breathe repeatedly. In total lack of deference to anything Mr. Floyd said, the police hogtied him at one point. They used a variation of what's called maximal restraint technique to secure every part of his body. And at one point, when concerned onlookers expressed fear for Mr. Floyd's life, Derek Chauvin threatened to mace an off-duty firefighter who simply asked that he take Mr. Floyd's pulse. He also threatened other onlookers with mace, and one of his colleagues ordered onlookers to stop filming to move to a different location where the scene unfolding was not evident to onlookers. I think one critical piece of the government's theory is that Derek Chauvin continued to kneel on Mr. Floyd's neck even after Mr. Floyd stopped breathing, even after his colleague Kyung confirmed that Mr. Floyd had no pulse, and even after medical personnel arrived on the scene to treat Mr. Floyd. In fact, you can see from the video that one of the emergency personnel basically gestures and tries to physically move Derek Chauvin off Mr. Floyd's non-responsive body. So in a quote from the government papers, they say, for nearly 9 minutes, Chauvin knelt on Floyd's neck, Kyung and Lane remained atop Floyd's back and legs, and Tao continued to prevent the crowd of concerned citizens from interceding. The government also argues that we can understand Derek Chauvin's intent by the way he reacted to Mr. Floyd and the way he spoke to him. So as Mr. Floyd called for help, begged for relief, even called out for his recently deceased mother, Derek Chauvin simply responded sarcastically, "Yeah, but you're doing a lot of talking though." That's a direct quote. So in essence, the government is claiming that the cause of death here was suffocation through a combination of the restraints resulting in a heart attack. With regard to the other 3 officers, the government is claiming that they did not intervene, despite the fact that they also had signals of Mr. Floyd's medical distress, his absence of any threat to the officers or any onlooker, and the pleas of the crowd that had gathered. In addition, although this is unlikely to come out in the main trial, it will likely come out at sentencing if any defendants are convicted. The government is also claiming that these defendants committed the actions, all 4 of them, in the face of what the law calls aggravating factors. In other words, factors that increase the level of cruelty and therefore make them worthy of a sentencing enhancement. And so the government claims this crime was committed in concert, in the presence of children, while on duty, through an abuse of official power, i.e. because they were wearing their uniforms and their badges, after Mr. Floyd was already vulnerable, handcuffed behind his back, knowing that he had an inability to breathe, knowing that at some point he lost consciousness, knowing that his heart had stopped, and in total disregard for life and health, ignoring the pleas of onlookers for help, ignoring the statements of medical personnel that he had stopped breathing, ignoring the requests for medical intervention. One thing that is lacking that people may be surprised by is that the state at this point is not directly alleging that race was a motivating factor in this treatment, at least not in the pleadings that they filed thus far. Now, by contrast, the defense's theory of the case really pulls out the same sort of theory that accused police officers have used historically in trials, which I would call the blame the victim card. This also relies heavily on racial stereotypes that have been successful in past trials around the country. So Derek Chauvin and his co-defendants are claiming that they all used reasonable force. And they point to multiple factors, asserting that Mr. Floyd is to blame for his own death. In Derek Chauvin's court pleadings, he claims that the most likely cause of Mr. Floyd's death was a fentanyl or combination of drug overdose with his underlying health conditions. That's a direct quote from their pleadings. They also claim that Mr. Floyd had other medical conditions that led to his death, in addition to heart disease, oversized lungs, sickle cell anemia, and a recent COVID diagnosis. The defense claims that the reason Mr. Floyd could not breathe was not because Derek Chauvin was kneeling on his neck for almost 9 minutes, but because Mr. Floyd had drugs in his system. And they point to fentanyl, possibly a speedball, and other drugs that they allege he was using. They also claim that Mr. Floyd was a longtime drug addict, and in particular, addicted to opioids. Their theory of how this crime or how this event unfolded was that Mr. Floyd and his Confederates were trying to conceal drugs, and that was the reason for their anxiety and their lack of compliance with police. They also claimed that he, Mr. Floyd in particular, had a practice of trying to hide narcotics when approached by police, that his fear wasn't based on his interactions with police, but his own alleged criminal conduct. They also claimed that Mr. Floyd had a criminal record, had a record of consorting with other criminals, and that essentially he was a large, unruly man who was struggling against police. They point out multiple times his size, the fact that he was about 6'4" and weighed over 200 pounds, and that he was resisting the police's lawful directions. And the government's response to all this is that although the autopsy showed that there was some level of narcotics in Mr. Floyd's system, that in no way was the predominating factor or reason for his death, and that the drugs plus the underlying health condition could not be the sole cause of Mr. Floyd's death, and that the prominent cause of Mr. Floyd's death was Derek Chauvin cutting off his air supply by kneeling on his neck. So that is what this case comes down to in terms of contrasting the different theories of how police can use force against suspects.
Thank you, Professor Pauls, and thank you for the broader context with regard to the historic nature of those arguments. That is, I think, very helpful and will be very helpful for those who are in attendance today. The next question, and we're going to begin to take questions from the audience after this next question. So if you have those questions, please feel free to put them in the chat. I know that Professor Osler has answered a few of those already, but certainly queue those up at this point. Professor Osler, you mentioned in the beginning, you have a piece coming out in CNN tomorrow that warns that we should not anticipate that this case will turn on issues of race, and that we should be thinking very clearly about decoupling those as we think about this trial. Despite that, there's certainly going to be significance for this case in terms of conversations around racial justice, conversations about police brutality reform, and systemic bias. I would like all three of you to weigh in on the implications for this case in that arena, both legally, not solely in terms of this case, but in terms of conversations about the legal system, and in any other way that you think is appropriate as we help this audience kind of unpack this. And I'd like to begin, if you don't mind, with you, Professor Moran.
Sure, thank you, Dr. Williams. In one sense, this case is incredibly significant for our country's reckoning with issues of racial injustice. I'm a defense attorney. I don't necessarily always put a lot of hope or faith in the ability of criminal prosecutions to remedy things. But one of the tragedies that is at the forefront, perhaps not of the conversation and trial, but of most people's minds, is this case is emblematic of a long history of Black people being killed at the hands of white people, and white people having legal impunity for those actions. A couple years ago, I went down to the Equal Justice Initiative's memorial around, that memorial is specifically centered around lynchings. And it's impossible to decouple this case from the history of racial injustice in our country, and specifically of violence toward Black people, and not being white people getting away with that. And so in one sense, I think for many people, this trial is a cry for some level of justice, for someone to be held accountable for that kind of a killing. On the other sense, though, I do think we have to be realistic